if we've had a revision of what our sources of law are and where we can find them, the next thing we want to do is have a look at reading the law and actually delving into some of these primary legal resources. So we're going to have a quick look at an act and a case to look at some of the main elements of the actual law. Let's go. So before we get into that, we want to just have a quick overview of legal citation. So what we have here is a way that we write or refer to the law, both legislation and case law. Now what you can see is that when we have a piece of legislation, we have the name of that legislation. So here we have the Competition and Consumer Act. We have that it's an act, so that means it's a law. See, as opposed to a bill, if it wasn't a law yet, it's now a law. That's because it's an act. We have the date that it comes, that it's been assented to and comes into action, and we also importantly have the jurisdiction. So this is the Parliament that passed it, right? This is where it applies. This is a piece of Commonwealth. So this is a federal, or this is a Commonwealth or federal piece of legislation. If it had Queensland there, QLD, it would be a piece of Queensland legislation. So we can actually tell quite a bit from the citation that's given to us for the law. Now below this we have a typical case. This is in fact an English case, and it's a very famous case that we'll come to when we do negligence. So the first thing that we can see are the parties to the case, right? Donahue and Stevenson. Generally, if it's first instance, the first time a case comes, the plaintiff comes first and the defendant comes second. Now we know that if it goes on appeal, that the terms change, and so can the order. On appeal, the first person is the appellant and the second person will be the respondent. Okay. Now it's not necessarily, don't take my scribblings here to be that it's always a defendant respondent, because of course if the plaintiff wins in first instance and the defendant appeals, then the defendant will become the appellant at the next order. Okay, so imagine we have Nicholson versus Smith at first instance. Nicholson is the plaintiff, Smith is the defendant. Now if Nicholson wins and Smith appeals, the second court case will be Smith and Nicholson, right? Because Smith is the appellant and Nicholson is the respondent. Okay, it's always who's bringing the case, who's got to establish their case and prove their point of view comes first. They're bringing the case. And so you'll notice that in this Nicholson and Smith example, Smith is an appellant defendant and Nicholson is a respondent plaintiff. You always keep this title whether you're a plaintiff or defendant. It's only the appellant or respondent that shifts as you go through the appeal process. Okay, so we've got our parties. Notice the V, which is always pronounced and in civil cases. It's because it's a Latin word, so it's Donahue and Stevenson. We have the date of the case. We have the law reports. So that again tells us the jurisdiction. And this tells us these are actually British appeals cases. So this case comes from the English courts that we've adopted here in Australia, and we can find it on page 562 of this particular series of law reports. Okay, so again, this case law citation gives us quite a lot of information: the parties, the year, what the jurisdiction was, and how to find it. We can go to these various sources, and I'd encourage you to do that, to go to these websites that will help you actually find the law. Go on there, see if you can find the Constitution, maybe see if you can find the Plain Packaging Tobacco Act, etc. Find a couple of acts and have a click round and see what the law really looks like. So what we're going to do now is just have a quick look at a couple of pieces of law. The first one we want to do is have a look at a piece of legislation. So what we have here is I have a quite dodgy scan of the page in the book, but it's an example of what an Act of Parliament contains and what it has in it. So the first thing we can see here is the title of the Act, the Radio Licence Fees Amendment Act of 2007. Note this number 69, so it was the 69th Act in 2007. We can also see that it has a short title, Radio Licence Fees Amendment Act. It's the same thing. Sometimes it's not. Sometimes the title is very long and we use a shortened version to refer to it. It was assented to on the 28th of May 2007. Okay, so that's when it came into being. That's when the Governor-General signed it. And so that's one of the reasons that we wanted to go through that process and understand these terms. We can also see that there are sections. Section 1, short titles. Section 2, commencement. Section 3, schedules. So when we're referring to a section, it will be a numbered part of the Act. Okay, so we can look at an Act and we can go to the Radio Licence Fees Amendment Act, Section 3. And that's what the section actually says. Okay, so that gives us an idea about what an Act looks like. Now we can also look at case reports, and they vary greatly. They can go from half a page to, as it says here, in complex cases, more than 500 pages. Sometimes that has to do with how many judges are actually expressing an opinion. So the longest cases are going to be those that go to something like the full court of the High Court, and all of the judges write their own opinion. So judges not only make a decision, whether a case is proved or not, but they also give the decision and how they reach the decision. We need that because that is what leads to the ratio something will come from, which is important to the doctrine of precedent, which we're going to deal with next. Now, if there's more than one judge, each judge can provide an individual judgment. So here we have a very famous case that was about native title, yes? So Eddie Mabo, Uncle Eddie, and the state of Queensland was the defendant. So we've got the parties, the plaintiff, Uncle Eddie, and the defendant, the state of Queensland. We also have that this is in the High Court of Australia, and we have when it occurs over 1991 to 1992. We have the judges who were sitting on it: Mason, Brennan, Dean, Dawson, Toohey, Godron and McHugh. So we've got everyone being involved. Now the next thing that we can see are these catchwords. Okay, so these are like keywords to understand what the case is actually about. And these were very important prior to computerization. They're still important. So if you want to know what the case is about, the reception of common law in a settled colony, etc. So, and the effect on the title of Indigenous people. So we can start to see this is about native title, okay, and particularly the doctrine of terra nullius, okay. So what we then have is a setting out of the facts. I won't go into a lot of detail about that, and then, really importantly, a summary of the decision. So this is where the judges actually set out their decision. So it was held by Mason, Brennan, Dean, Toohey, Godron and McHugh, with Dawson dissenting, that the land in the Murray Islands is not Crown land within the meaning of that term. Okay, so they're starting to set out, and then we start to get their reasons for that decision as they go through. What you can also see set out here, right, observations by Toohey J. Okay, so this, right, these were some cases and some ideas that were not followed, right? So they were considered obiter dictum, and we'll come to what that means. This is non-binding kind of ideas, observations, rather than the reason for the decision. Okay, so it's important to understand that this case, what's written here is the law, particularly this ratio decidendi, this judgment. This is what lawyers have to read to work out what legal principles actually are, and what non-legal principles but persuasive arguments might be, this obiter dictum. And we'll work out how that works next when we look at the doctrine of precedent.